How are you today?
I'm well, Clarence, and how are you doing?
I can't complain, thank you. I'm quite enjoying this lockdown and the peace that comes with it. The opportunity to think. The opportunity to think peacefully without chasing your tail. Tell us about Resolve and Change Systems. Let's start there. When did it start?
Well, Resolve and Change Systems started about 5 years ago, but I have been running a practice in dispute resolution, for the past 20 years, called Mediation and Transformation Practice, and then we moved over to Resolve and Change Systems because I thought there was an important need to look at resolving at dispute from a more systems perspective. You know, often what we do when we resolve conflicts is very ad hoc, it's crisis orientated, and yet it is about how do we resolve disputes in a way that it's win-win and that the outcomes are amicable and that we can implement those agreements in a sustainable way within our lives, within our workplaces, and within our society.
Okay, so we by and large familiar with litigation or arbitration. We know how expensive and how time-consuming that can be. Is this a process of mediation, this alternative dispute resolution that you're proposing?
Most definitely. See, we come from a very rights-based society where in the way we resolve disputes is either we use power or we use rights. Now, if we use power, then it's often violence or we're being imposed upon or being oppressed, and the most powerful person then becomes the winner. So it's a win-lose outcome that's from that perspective. When we go to the courts, we appeal for our rights to be protected. And again, that litigious process is often an adversarial process. Because out of the litigious process, having our rights being protected or defending our rights, there's often also a winner and a loser. Now, you know, if we look at mediation, mediation is a needs-based process. Mediation says, listen, we have different perspectives. We are approaching this from a different angle. We have different needs that needs to be met. But we can go into a process of dialogue. We can talk about it. And when we talk about it, we have the opportunity to try and understand what are the needs that's absent for the parties, and what are the options, and we can be creative in looking at different options to resolve that and find an outcome that actually works for both parties.
So you're saying that there are two adversaries, both are willing to resolve a dispute?
Definitely. I mean, in any conflict we have different parties. We have parties who comes at it and who have their own perspectives. Now,
sure.
And what happens when we engage in conflict, we often come with our own positions. Now, what are our positions? Positions are our needs framed in the form of a demand. I want, I will, you can't, you must. When we engage from a positional base in our dialogue, in our engagement, in our negotiation, the other parties will also take in positions. And the more we engage in others' position, it simply escalates. And then from was probably just an ordinary conversation like, it goes up and it escalates and people start to be very aggressive and adversarial in that engagement. And often it lands in an impasse and that conflict doesn't get resolved and the relationship actually gets irrevocably damaged in many of these instances.
And the resolution of such a conflict through litigation and arbitration is expensive too, which could disadvantage a party in that dispute.
Very much. I mean, when we go to court, you obviously have to go and first have a consultation with your lawyer and that engagement, and then you go to court. And that in itself takes a long process and is very expensive. And yet there are many cases. Now, I'm not in any way bashing litigation. I think litigation is important. There are certain things that needs to go to court. But there are many conflicts, there are many issues that we can resolve through dialogue, by sitting around the table, having a third party intervener who is independent, who is impartial, who allows the parties to share their perspectives and help them to find an outcome that's amicable. Even within our court-based system now, there's a new rule that's been issued by the High Court, Rule 41A, that says before anyone can come to the High Court and engage in the High Court, they will have to engage in mediation first. If they don't mediate, they'll have to give a very good reason why they are not prepared to go into mediation.
Oh, that's great. Okay, so mediation is proposed. In fact, it is forced on you as a means of finding settlement before litigation and arbitration?
Yes, and I think what the courts wants to do here is to move us away from an adversarial society. It's creating a new culture of collaborative problem solving. If we're going to be engaging always from an adversarial perspective, you can imagine what kind of culture are we creating in terms of having needs met. It means the person who's got the most power, the most money, access, that person will always win. Where through dialogue we can come to a different space and a different engagement.
So are we talking about a saving of money and time? Is that the benefit essentially of out-of-court settlement processes?
Most definitely. If you settle out of court, now we've got a system in our out of court settlement practice where I say to my colleagues, we're going to use 10 hours. Because I feel in 10 hours of engagement with parties, if you have not resolved in 10 hours, then you're almost probably not going to resolve it through dialogue. Because what it is about getting parties to talk about the issue, to understand where the issues are coming from, and look what are the options. Now, if 10 hours versus spending days, hours, months in the courts trying to fight a particular perspective is far more financially viable for parties. But it's not just from a cost perspective. It is also from a relationship perspective. Now, if you take families, if you take a divorce, invariably the parents will still have to look at the needs and interests, and the family court Children's Act, it talks about what is in the best interest of the child. Now, as parents, when we sit down and we look at the common needs and interests of our children, then we are more able to meet that needs instead of going to the court where we fight each other. And when we fight each other, then we are not able to build the bridge beyond that.
Adversarial. I'm just wondering how you're going to be able to get it into a more kind of problem-solving kind of mode. But interesting. Just before I go on to the other questions, what is your success rate in terms of you've been doing this for the past 5 years? Just how successful have these outcomes been? Not just in terms of numbers, but also in terms of relationships that you are serving.
I've been involved in dispute resolution, I guess, for the past 20 years, and I've been very fortunate to work nationally, internationally on it. In South Africa, in terms of the work that we've done, we've had a very high success rate. So at a number of institutions, we called in to facilitate or mediate labor disputes. Not just labor disputes, but interpersonal disputes. I've been involved in very big public disputes where I've been part of negotiating and facilitating and mediating outcomes. Those outcomes have been very sustainable, and it's created a new way of being and doing within that institution and within the public space that we've worked in. So we've been very, very successful.
You think outcomes are sustainable to the parties involved?
Most definitely, because you see, it's the parties who decide on the outcomes. They're involved in designing, in creating those particular outcomes. So it's not imposed upon. When something's imposed by a judge or a magistrate or arbitrator or a principal upon you, then people always push against it.
They're not taking the responsibility themselves.
Exactly. In this very case, people are involved in designing it themselves.
Okay. So tell us about the RACS resolve and change systems, the kind of disputes that you have been resolving.
So we've been very involved in kind of organizational disputes. So within institutions with the organizational issues, we come in and we get the parties together, we facilitate dialogue. We've also, because a number of my colleagues are legally trained, we're also involved in labor disputes and engage in those kind of issues. We have been called in around public disputes. So for instance, in one particular community, there was an issue with regard to the implementation of a bus service, and there were different parties involved in that. We were called in as the independent negotiators, facilitators, got the parties together and built trust and dialogue, and through that kind of got the opportunity for the parties to find an outcome that benefits that town and that particular community. Then also, with our out-of-court settlement practice, we have a number of people that's coming who's got was probably a conflict with a partner, be it a business partner in the business. And so rather, instead of going to court and fighting each other there, we sit them around the table and we engage in dialogue and find ways how to kind of exit a dysfunctional relationship and partnership in a way that both parties feel that their needs have been met. So there's been a number of cases that we've been involved in.
Craig, we're gonna have to wrap up. My last question to you: have people responded to this new means to resolve a dispute? I think a lot of people know about it. Are people learning about it? Are people knocking on your door?
You know, within institutions and government departments and businesses, it's something that's become very apparent, and it's very present in the way that they operate, particularly because of the fact that legislation also puts that out for them.
So you confirm that there's a growing need for the service?
There is a growing need for the service. It's definitely moving away from competition to more place of collaboration.
I like that. I think that's a great place to rest our conversation as well. Craig Arendse is the CEO of Resolve and Change Systems, RACS abbreviated. Do you have an online presence? Where can people find out more about your business?
Yeah, you can find us at www.racs.org.za, or they can go to www.outofcourtsettlements.org.za.
Outofcourtsettlements.co.za or racs.org.za.
Yeah.
Do you need to be grounded in the law? Do you need to have some kind of legal training to conduct this mediation process that you are doing?
No, not. You don't need to. We've got a number of colleagues who are legally trained, because obviously some of the conflicts are rights-based and legally based. But a number of our colleagues have backgrounds in education or psychology or social sciences.
I imagine this takes emotional intelligence more so than legal training.
Very much. It's about people. It's about collaborating. It's about making things work for all of us.
It's been a privilege chatting with you, Craig Arendse, of Resolve and Change Systems CEO. We appreciate the time and the insights.
Thank you very much, Clarence.
Take care, Craig.
Take care. Bye-bye.
So that's what we're doing.